Digital money lenders are under the scrutiny by the Personal Data Protection Office of the National IT Authority for their abuse of the data they acquire from borrowers. A case in point is incidences of harassment of third parties known to the borrowers as blackmail to force payment of borrowed monies in case of default. This was on the sidelines of the release of a data protection survey on data protection compliance by Ernst and Young.
On our side, we've received a number of complaints that we are looking into in regard to digital money lending applications. That is where we are seeing a lot of abuse, and one of the things we want to do is to, in our sessions, to talk about them, because the people who obtain loans from these digital money lenders are really people who we know are not yet aware of their rights.
The Ernst and Young report highlights major risks in organizations around poor management of client documents, limited consent rights, and information confidentiality breaches.
There's a bigger conversation that is coming up around consent management. We are being asked a lot of data that is being collected about us as citizens. So we are then needing to find out what consent management is going to be the gold standard, where I accept, but also be able to follow up and confirm that you are using the data for the purposes to which you collected.
Well, the requirement under the law for consent is that it has to be explicit. In other words, it has to be clear. The language should be simple enough for someone to understand. You should provide enough information to the data subject or to the individual whose data you're collecting to ensure that they are informed.
Organizations that are liable to data privacy breaches are required to pay a fine not exceeding 2% of their annual gross turnover upon conviction by court. Paul Murungi, NTV Business.